Both introduce yourselves and for the record, please.
Yes, William Christopher Hicks, Assistant City Solicitor for defendant City of Cincinnati, respondent.
Okay, thank you, Mr. Hicks.
I'm Lieutenant Jeffrey Neal, Cincinnati Fire Department. I'm the appellee.
Okay, thank you. All right, so we'll have 15 minutes per side for argument. I'll keep the time. Mr. Hicks, would you like to reserve any time for rebuttal?
I just reserve 3 minutes, Your Honor.
3 minutes. Okay, you may proceed when you're ready.
Thank you. May it please the court. We are here today on an appeal related to a fire captain promotional examination that was given in late 2015, early 2016, pursuant to the civil service laws of the state and the City of Cincinnati. This examination, very briefly, involved 5 different sections: a video section, a written section that were given initially, and then what was called the assessment center. And this was given over 3 days, involved 3 different sections: a tactical examination, a written examination, and an interview section. And during those examinations, that portion of the examination is given at a location where all the candidates appear, and involves an outside vendor who conducted the examination for the City of Cincinnati, and outside assessors used so that there are not individuals from their own department who are assessing the individuals at that time. And they are about 12 individuals who are from various cities, Cleveland, St. Louis, all over the country. They fly in and act as assessors, and they're usually at the rank of the candidate or above the candidates, and that is used to try to create fairness.
So, Mr. Hicks, I mean, what is the remedy, if any, for Lieutenant Neal's concerns about irregularities in the testing?
Well, he can go, as he did twice, April 28th and I believe October 10th, I may have that date slightly off, to the Civil Service Commission for what's called an appearance. Obviously, the reason this is brought as a writ of mandamus is because he doesn't have an administrative appeal under 2506, because there was no quasi-judicial hearing before the Civil Service Commission. Under Rule 17 of the Civil Service Rules, there are various different issues that can be brought to the Civil Service Commission as a appeal of right. For example, dismissal, separation, demotion, suspension in excess of 3 working days, the results of criminal background checks, layoffs, failing to meet the qualifications. However, how the exam was conducted, whether distractions impacted his score, which is what we're dealing with here, the cell phones going off and one of the assessors allegedly falling asleep during part of the examination. Though I would note he asked 2 of the questions during that session, so it must have been quite a brief sleep. But that being said, his remedy is to go to the Civil Service Commission and have an appearance and ask for their assistance. And I've been there numerous times, and even though those are not quasi-judicial hearings, very often people will get relief in front of the commission.
But if the Civil Service Commission denies relief, then there's no further ability to seek relief, or is there?
Then his relief is what he alleged here, which is a writ of mandamus. While he did bring an initial as a judicial, an administrative appeal and a writ of mandamus, obviously those 2 remedies are mutually exclusive, because if you have as this court is well aware,
Right. Well, take a more extreme example. Let's say that the commission or the testing people not only fell asleep, but they didn't record any of his answers. And so they didn't grade him, but they graded everybody else. Would that rise to a level of triggering mandamus?
It possibly would. Well, one, the Civil Service Commission would most likely take that opportunity to do something. I mean, that's where they can utilize their very broad discretion in this particular area. They have very broad discretion to interpret the civil service rules, and particularly in the area of promotional examinations, as the courts have found all over the state. But, you know, as long as there is, as this court, and I think this case is very key, the most recent decision in Lanter, as long as there is a specific, definite, clear, and unequivocal, you know, duty provided under the law. But a mandamus is an extraordinary remedy that's, you know, very reluctantly granted. And so if there was some sort of very extreme situation, then you may be able to come upon a specific duty, a clear right and a clear duty under the law.
Let me ask Mr. Hicks, is
Yes,
an
Your Honor.
appeal to the Civil Service Commission, do you believe that's an adequate remedy at law?
An appeal to the Civil Service Commission.
Yep.
No, I mean, I think that's why he has an ability to go to file a writ of mandamus. I'm not saying that he does not have the right to bring. I just don't think this Civil Service Commission, that did not satisfy the adequate remedy of law in this circumstance, because he didn't have the right to appeal that to the Common Pleas Court.
Okay.
But after this, the examination, he voiced a vocal complaint at the time saying, the cell phone went off, I was distracted. He was comforted by, the people at the time said, look, the three assessors come to a consensus. They have to be within 5 points of each other. If one guy was a little off or was distracted, and in the paperwork during the orientation, they were told that they had to be able to adapt for, the people at his level, at captain level, must be prepared to adapt to changing conditions. So after the exam was given, the commission certified the eligible list on March 10th. There was no written complaint brought until March 15th regarding, on March 10th, they started promoting people off that captain's list. And March 15th, the appellee brought his written complaint and then attended the April Civil Service Commission in order to try to seek.
Are you suggesting that his complaint was too late?
I'm asserting that differentiates it from one of the complaints that they try to compare it to, that of Lieutenant Melissa Arnold and a group of 3 other individual candidates. When they came into the examination, assessor packets, the questions, one of the questions in the tactical exam did not match the answers in the packet, or the questions in the packet that the candidates had. And that was the very beginning of the exam. And they had to stop the exam, figure out what was going wrong, and they realized that these didn't match, which would have fundamentally impacted the entire examination for all candidates. And so they had to stop. They figured out what the problem was, and they gave the first group of candidates a chance to 2 more minutes to answer that specific question.
So is what you're saying that if you raise it more timely, there is an ability to correct issues and maybe remedy them in real time rather than waiting until after the fact?
Yes, and I think in some ways, based on my somewhat background with discrimination law and with freaking and other firms, the similarly situated analysis, I'm sort of analogizing that to this situation, that those aren't similar situations. Just because they were given 2 extra minutes, that doesn't mean he gets the extraordinary remedy here, which was great. And I think that's important to note. He finished 42 out of 54 on this examination. The court, and the list was certified March 10th of 2016. The court took the extraordinary step of not only saying, I think you should move up because of these distractions. I'm going to move you up from 42 to number 1, where he was nowhere clear. I would have been much more sympathetic to appellee's situation if on the 5 parts of the exam, he had finished really, really well on everything except for the 2 sections where there were alleged distractions.
Mr. Hicks, how would you compare this to the Rimroth case?
I'm sorry, Your Honor, I did not hear that.
How would you compare this to the Rimroth case?
The Rimroth case?
Rimroth.
I'm not.
That's the case of the firefighter in Harrison, where there were 3 candidates. One of them was eliminated by the mayor, and then the other one didn't score high enough to pass the exam. And this court determined that the third one was not eligible for promotion or did not show that he was eligible for promotion. Do you find this to be similar?
I would not, that case, the candidate, I believe, was number 1 on the list, and here, he's 42nd on the list. He's way down. This isn't a situation where the next person moved up. This is someone who finished 42nd, way down on the list, and it was not, and it wasn't a situation where the mayor or somebody took an affirmative action to say, I'm not going to promote this person. This was a situation, where he essentially jumped the whole other, and it was merely a dispute whether the distractions were sufficient to justify moving him that extraordinarily far up the list, as opposed to you're number 1 on the list and then you move up, or 1, 2, or 3. This is I think distinguishable in that regard factually. So as I was saying, I'd have much more sympathy if it weren't for the fact that on the top 25 were promoted off of this list. On the parts that other than 14th on the written portion, the appellee finished between 39 and 43 on all the other sections of the exam. Had it been, he finished, 8th, 7th, 6th, 5th, and then 50, second on the section where he was distracted, I would have more sympathy. And I think it's important to note, in this
Well,
case,
and didn't his expert acknowledge that there was no way to know whether he would have made it to 25, even in the absence of the distractions?
that's correct, Your Honor, and that's so actually I was going to note that because there was just no way, and I think this is such a leap because of mandamus being such an extraordinary remedy, and to have such a, as the court noted in Lanter, I think relying on the Manley case that mandamus is appropriate where the right is clear and does not depend on complication of disputed facts. And here we have lots of disputed facts and a lot of speculation, and the court essentially jumped from.
Mr. Hicks,
Mhm.
when part of the reason for the speculation seems to be that all of the records were destroyed. Is that true that everything was destroyed?
That is completely false. We gave piles of documents. I carried over piles of documents. Now, some of the records are pursuant to our contract with Ergometrics, which is in the record. There are proprietary documents. These outside assessors that do these tests for us to primarily try to avoid having a disparate impact problem, which is a concern under the 78 EEOC guidance. So these firms can't just have all their testing materials and all their proprietary information immediately released, or everybody's going to copy them, and they're going to be out of business. So pursuant to this, on the day of the exam, the assessment centers, some of the documents are taken and shredded pursuant to the contract. But I believe that their experts, opinion was, I don't agree with it, but I think it was immaterial here. But he, in essence, it supported our case. And so
And
I believe
Mr. Hicks, you're at your time if you wish to reserve time for rebuttal.
Thank you, Your Honor.
All right, Lieutenant Neal.
How are you, Your Honor? Most of the stuff that he just said is factually incorrect and total speculation. To get to some of your points that you made and or asked about, he states moving from 42nd to 25th. I was 42nd, and what the city is trying to do is take their own failures and use them against me. They had their own failures in the testing process, which negatively impacted me and negatively affected me. We had cell phones going off. We had people getting up, walking across the room, rooting through their bag for their cell phone. We had an assessor falling asleep. We had another assessor laughing and texting through multiple questions of the exam. So when you couple all that together, and including the fact that as soon as I walked out of the door, as soon as I walked out of that door, there was an ergometrics representative, and I filed an oral complaint. The same type of oral complaint, the same type of complaint that the first four filed. There was no written complaint. There was no written form. There was no written anything to file. It was all done orally. I filed my oral complaint And just as in the response that we got from Ergometrics, they state that the candidate did bring up this issue with Ergometrics after completing the exercise. Ergometrics did not discuss this with the city on the day of the exercise. So Ergometrics, after already stopping the process for an hour for the first 4, hid my complaints from the city, but they were under contract to put on a fair, competent test.
Well, let me ask you about that, Lieutenant Neal, because it's one thing to say, I want a fair test. I didn't get a fair test. I want another chance at that. It's another thing to say, I didn't get a fair test, so promote me anyway. And so how do you get from I didn't get a fair test to you must give me the promotion?
Well, so when I went to meet with HR, their overview of it, the assistant HR director said, it was like everybody was given version A of the test. You were given version B of the test, yet everybody, including you, was scored off version A's scoring identifiers. So when you're scored off of another test scoring identifiers or indicators, there's no way that you can have a fair and competent test compared to everyone else. And state law states, ORC 124.45, which the city keeps using 124.44, which is the police department. 124.45 states that the position shall be filled by a competitive promotional examination. So there's no way to have a test that is competitive for everyone, but unfair for 2 or 3. You can't, that doesn't correlate. You can't have a test that's unfair for 2 or 3 and then yet competitive for everyone. The other thing that the city doesn't want to bring up is that for the first 4 candidates, they did this for them, they did not do for me. Immediately addressing the procedural error and developing an immediate remedy. They stopped the process, they took a look at it, and they developed an immediate remedy. They hid my complaint, they did that for the first 4. Second, they discussed with the assessors at the time of the procedural error whether or not the error affected the scoring process. They did that for the first 4, they did not do that for me. Then they conducted a statistical analysis to verify that the procedural error did not have a statistically significant effect on the scores. So when you take all of that, plus after I file my oral complaint, they give the first 4 a chance to redo their test.
But the problem with the comparison to the first 4 is this isn't a constitutional claim for equal protection or something like that. I mean, we're limited to a complaint for mandamus, and mandamus asks what happened to you, not what happened to other people.
Right, so that is what happened to me. After I filed my oral complaint, the city went and destroyed all the assessor notes, the assessor packets, the scoring indicators, all of section 5, including the written presentation. Then, just like my subject matter expert said, it is unbelievable to him and against all nationally accepted norms in assessment center testing that there is no video or audio tape recordings to go back and review. So they destroyed all the evidence for the entire assessment center. There's not one piece of paper that's there for the assessment center. We went through, we filed 9 public records requests. We filed a second mandamus claim. That mandamus claim was rolled into a motion to compel. After the motion to compel, Judge Ruhlman asked us to send Ergometrics a subpoena and carbon copy the city on that to get records. Because pursuant to their contract, Mr. Hicks was supposed to do that and get the information. He never did. So we filed in the motion to compel, we filed a subpoena. They then sent back and said, we are not bound by a subpoena outside of the state. We're not giving you any records at all, which to me, that violates the Sunshine Rules, Chapter 1, Section 3. But beyond that, so we still couldn't get any documents. So all the documents were shredded. Then we couldn't get any of the documents from them. Then at trial, Amy Luthanen, who ran the test, stated on March 13th, page 10 through 13, that, oh yeah, I actually have all of the proprietary information saved on my computer, and I would have given that to Will Hicks, and it's Will Hicks' duty to give it to you. Will Hicks didn't turn that information over to us. And so how am I supposed to go and get any remedy at all when they do not retest me after my test is significantly different? Not only significantly different, the testing process was set up to be a true static-based test. This was not a true static-based test. And that's why Nancy Olin stated that it's like version A, version B, version A, is that you didn't have the opportunity, you didn't have the ability to be even with everybody else. Your test was systematically different. My test was, it went from a true static-based test to a static-based test with distractors. And
Mr. Neal,
yes,
why not just seek the opportunity to take a new test? I'm not sure I understand that.
there is no ability to take another test. That is the only test. So after I file my oral complaint, they do not retest. I filed 2 oral complaints. After they do not retest me, then I'm done for several years until they hold another promotional exam. So that's wronging me out of the promotion. That's wronging me out of compensation. That's wronging me out of pension. That's wronging me out of all kinds of issues for that period of time between the first test and the second test. And the problems happened on the first test. So they are obligated under the law to fix and make sure that that test is competitive for. This is not 1, 2, or 3 questions that are back and forth. This is 50% of the exam. Then after being put on notice that there was a problem with 50% of the exam, not only by me, by other people also who filed complaints, they shredded all the documents. So if you go off of 124.45, and he talks about the quasi-judicial hearing, Judge Winkler brings up, is that an adequate remedy? It states this in 124.45. After the grading of examination papers, any participant in the examination who considers the participant's examination papers to have been erroneously graded shall have the right to appeal to the commission, and the appeal shall be heard by the commission. They don't have the discretion to not hear my complaint or my appeal. It says shall, and shall means shall. They shall hear my complaint if I, the participant, feels that my test was erroneously graded. The problem with that is by the time I would have gotten there, the city had already destroyed all of the evidence. The city had already destroyed all of the issues for the grading and the scoring.
Wait, I guess I'm confused. How are you saying you were erroneously graded? I thought your concern was that based on the distractions, you were not able to perform to the level you would have otherwise performed without the distractions.
That's true. That's true. But with the scoring,
then where does the incorrect grading come in?
Well, so with the scoring and the scoring indicators, that goes into your grade. There's 5 independent sections. Nowhere has the city been able to say, and there's evidence that one section has any bearing on the other section or any other section. There are 5 totally independent tests. So when you take those scoring indicators and you go in and you go through the process hoping that it's competitive, you give your answers. It's supposed to be all 3 examiners or all three assessors looking over your grade and grading you. If they can't go through and check on the scoring indicators, yes, he laid off. Yes, he did a 360. Yes, he did that. All that scoring goes into your grade. Then that grade gets combined in with everything else. If you have 2 grades out of those 5 or 3 grades out of those 5 that are not correct, then your overall test, your overall score and your overall grading isn't correct.
Right, but is it not correct because there was an error in the grading, or is it not correct because they weren't paying attention to you?
It's not correct because they totally changed the makeup of the exam. The makeup of the exam went from a static-based test to a static-based test with distractors. And not only a static-based test with distractors, it went to a dynamic test. So therefore, in the grading of it, if you're grading an exam and you give everybody version A of the exam, I get version B, yet everybody, including me, is graded off of version A's exam, then the grading is messed up for me. Does that answer your question?
It does. It does. I guess I understand what you're saying, but that doesn't, I mean, I think we're comparing apples and oranges to say that there was a flaw in the grading, because it's not as if they incorrectly marked a question right or wrong when it was right.
Well, sorry.
No, so I think that, so I'm not sure what the destroyed records would show that would help your claim at the end of the day.
Well, it would help my claim because as my subject matter expert stated, and they want to cherry pick one sentence out of a report that absolutely hammers the city. But if you may, before I go on to that, the city can't even tell me where I would have placed. Amy Luthanen, who ran the test at the exam, stated, or at trial stated, it's possible he would have done better without interruptions. We don't know for sure. There is no way to tell exactly how much better. So if the person running the exam doesn't even know where I would have placed because they destroyed all the evidence and destroyed all the material that would help me in my case, then nobody can know. And so you ask, well, what would the scoring indicators do? The scoring indicators go into grading. So the city even states in their brief that the scoring pursuant to the contract, that the scoring each as proprietary information, the scoring details, the notes, and anything else were shredded that night, which they weren't shredded that night. They were shredded a week later. But so everything that goes into the scoring, as far as the scoring indicators, that those check marks as they go down the scoring indicators tell you if you've met that objective or you haven't met that objective. So once they shred that, there's no way to go back and tell. And like Fern, so there's one or two questions that you can go back and say, yes, he answered it, or no, he didn't answer it. And yes, that's a correct answer, or no, that's not a correct answer. But for the city's argument, there's no way to tell because they've shredded all the documents. So once you go to civil service, there's no way to go back and look at, was that answered yet correctly or not? Because they didn't videotape, they didn't audio tape, and then they destroyed all the evidence. And whatever they didn't destroy, they sent to ergometrics and we couldn't get back. So that's the problem with the case.
Okay, thank you, Lieutenant Neal. You're at your time.
Yes, thank you, sir.
Mr. Hicks, you have 3 minutes.
Thank you, Your Honor. Just briefly as to the duties that being alleged that I did not fulfill pursuant to the ergometrics contract, that contract is Respondent's Exhibit E, and it clearly puts out my duties and our duties under the contract. It also clarifies the destruction of documents that's supposed to occur pursuant to that contract. And the public records, we're not supposed to go out and get this public records from them. We're only supposed to notify them of an intent to release material under that. And it clearly says the city will not maintain any test material on site and will destroy any electronic or paper copies in their possession media after use. But I also believe that those documents are really immaterial to whether he was distracted or not, and that distraction would have allowed him to move from 42nd to 1st. These examinations, we conduct dozens of them a year. And while we endeavor to make them perfect, there is no perfection in these. There's always some kind of computer glitch that happens or some other mismatching questions. And if plaintiff's case, if Lieutenant Neal's case were to be allowed to proceed under this, theory, essentially everybody would get a free, a fresh chance for the common pleas court to essentially substitute their judgment for that of the Civil Service Commission, and it would be a free fall. We never have any certainty in our testing process. And, the court's judgment for the plaintiff is in their citation is that there's a clear legal right that the test be administered competently, properly, and fairly in accordance with Ohio law. And I would submit under the Lanter case and numerous other cases, particularly in the circumstances where the civil service is reviewing the promotions in the civil service arena, an area where they have their discretion is at its height based on the case law, that is not a specific, clear, definite, or unequivocal citation to the duty. The only citation that to anything in the statute that plaintiff has noted is 124.45, which is a very, very insufficient to provide any specific or clear duty. And as the court noted in Lanter, even cases based on the First Amendment to the Constitution have been noted to be too vague to create a duty suitable for mandamus. So I think in the context here, that similar analysis should apply, and this court should reverse the judgment of the common pleas court. I would note just briefly on the attorney fees, we believe this is clearly inapplicable. For some reason, anything besides this should not, under the American rule, there's no fees in this type of situation provided by statute. And the back pay is completely without any basis because there's no certainty. You can't establish it with certainty under the Bednar case. I mean, we've got somebody moving from the 42nd to first. There was no real definitive showing or evidence establishing those rights.
Thank you, Mr. Hicks. Thank you both for your arguments today. The case will be submitted and we'll get out a timely written decision. We hope you both have a great day.
Thank you.
Thank you.
Thank you, Your Honor.